it's just after 12 o'clock. It's 12:02. I want to welcome everybody to the USA 500 Math Series, How to Sell Your Business, Buy, Sell, Hold, a guide to selling or buying a business. This is session 7, what to expect at closing, which is the last in our series of webinars we've been holding over the fall. My name is Keith D. I'm president and founder of Osage Advisors. We're a merger and acquisition firm based here in Connecticut. Since 2001, we've been working with business owners of closely held and family-owned businesses looking to sell. Our clients are up and down the East Coast with a main concentration in the Northeast, specifically in the tri-state area. Joining me today is helping moderate is Larry Thal. Larry is a partner with Excella business specialist. Larry's current role with them is business development. The company has expertise in designing, implementing employee and executive benefit plans for its clients. They service a wide range of products, including, but not limited to, health insurance, life insurance, disability, and others. Larry has a unique perspective that he brings to the panel today, as he has sold his company and he has been through the process. So he is very attuned to what to expect when you sell your company. Our panelists today, I'm pleased to introduce Scott Mottner. Scott is a corporate M&A and startup attorney with Harrington, Oko and Monk. Scott has almost 30 years of legal and business expertise, servicing corporate commercial real estate transactions, general counsel to his clients. Scott has represented numerous clients in both the buy side and sell side in M&A transactions, ranging anywhere from $500,000 up to $40 million. Scott brings tremendous expertise to this panel. We also have Andrea Cantor. Andrea is the founder of the law office of Andrea Cantor PC. Andrea has over 25 years of experience working with large law firms in the New York City area. She founded her own firm in 2009. She's a corporate counsel and advisor to small and medium-sized businesses. She advises companies throughout the corporate life cycle, from formation to capital raising to M&A to exit. Finally, we're happy to have Andy Adamowicz, who's also the founder of his own practice. Andy also works with various businesses. He focuses on the complete life cycle of the company's life cycle, including formation, capital raising, M&A. He also provides general counsel for related corporate matters to his clients. And he brings a tremendous amount of experience to the panel. So both the buyer and seller have been through a prolonged process. There's been a lot of negotiation, a lot of give and take, a lot of compromise. It's been emotional, it's been stressful, anxiety-ridden, but here we are. We're finally at the closing table. And so today, the slide is stuck. Sorry about that. Hold on, please. Here we go. Here's our panel. So here we are. You know, what to expect at closing. The first thing we talk about, and Andrea, I'd like to share this to you, is, you know, what kind of documents? So we have the purchase agreement, right? So maybe you can talk to us a little bit about what that entails and what the buyer and seller need to expect of us.
Okay, so as Keith said, the parties have gone back and forth and they've negotiated, and the main document is the purchase agreement. And one thing as to whether or not it's going to issue that comes up is whether you're going to have a signing and closing of the purchase agreement on the same date. And basically the form of the purchase agreement will vary depending on whether there's going to be a simultaneously signing or a deferred closing. And this is dependent on the deal or the industry. in my experience, usually there's a signing and a closing on the same date, which can be advantageous to both parties since it eliminates the risk of what could happen in the intervening time between signing and a deferred closing. But at some times you can't have that because there's regulatory approval that has to be obtained or shareholder approval or third-party consent. So then you need a deferred closing. And if you sign and close at a future date, rather than sign and close on the same date, in addition to the reps and warranties and the covenants that you have in a purchase agreement that's signing and closing on the same date, you have to have additional covenants that need to be negotiated in the intervening period. For example, you might want to restrict actions that the seller can take during this period prior to closing, such as not being able to enter into material contracts without the consent of the buyer, or they not being able to incur additional debt, or maybe even restricting them from getting competing bids. The agreement would contain, because when you have the reps and warranties, they're true as of that date. But if you have a deferred closing, you want them to be true and correct as of the closing date. And something that could happen, which I'm sure many of you are familiar with, is there could be a material adverse change in the business, a MAC clause, and that could give the buyer the opportunity to walk away. And a lot of deals go back and forth, and especially during these times, it's relevant. Another thing that's in the purchase agreement are disclosure schedules. And I can't emphasize the importance of disclosure schedules enough. They're usually prepared by the seller. And I would recommend that the legal and business teams get together and work on the disclosure schedules. What they are, and they should be started at an early stage of the process, and they go hand in hand with due diligence. They serve two functions. One is to provide detailed information to the buyer about the business. For example, it could list contracts over a specified dollar amount. It could list litigations, intellectual property assets. And the second is that they provide exceptions to the reps and warranties. And when a seller lists a liability on a disclosure schedule, it passes the risk of liability to the buyer. And the buyer has the opportunity to factor this liability into the purchase price. For example, a rep could state affirmatively that there's no litigation except as set forth on the litigation schedule. And an incorrect or incomplete disclosure could result in a breach of the purchase agreement and a liability to the seller. So it's my recommendation that it's better to over-disclose than under-disclose because you're protected from a risk perspective. Once seller lists an item on a schedule, this generally means that the buyer can't terminate prior to the closing as a result of that matter or make a claim for indemnification when a disclosed liability ends up costing the buyer more money. For example, if the seller lists litigation on the schedule as an exception to the litigation representation, the buyer can generally make an indemnification claim for breach of the rep if the litigation ends up costing him more money. A buyer should be comfortable with all the disclosures set forth in the disclosure schedule and confirm and be sure that the purchase price and other terms are appropriate in light of what they've discovered when they reviewed the disclosure schedules.
Great. Thank you, Andrea. It's terrific, and I can't overemphasize the disclosure schedules as a part of a transaction. It's
Keith, this is
yes.
Larry. I'm just interrupting for a second. Your version of the slides indicates all the notes. Do you have one that's larger? That's just the slide. That's we're being reminded to use that. Thanks.
I'll try again. How's that? Better?
Perfect.
So the disclosure, just saying, the disclosure schedule, as Andrea was saying, is a critical component, and you can't spend enough time making sure that you completely document the schedules. So you got the purchase agreement signed, and but that's not the end of it, right? There's things that happen after closing that need to be addressed, and Andy, maybe you can run through the trade, the post-closing.
Sure, happy to. Thanks, Keith. So whenever there's a significant time period between signing and closing, there's the possibility of fluctuations in the target business's operations from the time that the purchase price was determined when the purchase agreement was signed, and then again at closing. There's also the possibility of disputes about the seller's operation of the business between signing and closing. An example of that would be manipulation by the seller to accelerate the payment of receivables to maximize cash distributions to the seller before closing. This can all be dealt with by what's known as a working capital adjustment. This is distinct from an earnout, which we've discussed in previous sessions. That involves additional purchase price payments that are based on the performance of the business after closing, as opposed to what we're talking about now, which is a snapshot of the business at closing. So the overview of working capital adjustments is that at the timing of signing, the parties agree on a target net working capital at closing. Just to step back without getting too in the weeds of accounting concepts, net working capital is defined as current assets like cash, inventory, accounts receivable, minus current liabilities. Basically, it's the capital needed to operate the business day to day. And the buyer wants to know it will have this capital in place at closing, so it doesn't have to suddenly provide funding just to keep the doors open. So you have the target net working capital established at signing. Then just before closing, the seller delivers an updated estimate of net working capital. And at some agreed time after closing, the buyer will deliver its calculation of what net working capital was at closing. And there's a procedure for the parties to work out any disputes about what that amount is, or the net working capital statement. Ultimately, the adjustment to the purchase price as a result of this can go up or down in most cases, and the parties will often leave some amount of cash at closing in an escrow account to fund the payment for the adjustment. And the adjustment is also sometimes referred to as a true-up.
Terrific. So we get to the fun part, Scott, is the payment. And maybe you can kind of go through it. It's not as easy as it is just writing a check. There's a lot of fun. There's a lot of things that go into making that final review payment. Maybe you can run through some of these aspects of that for us.
Right. Thanks, Keith. So where we've gotten to is the closing date, which, as Andrea said, you can sign the purchase agreement on the day of the closing, or you can sign it a few months or weeks before closing, and then you have a gap period until closing. So what typically happens at closing, we do closings today by electronic means, meaning all of the documents are exchanged via PDFs between the law firms. What Andrew just alluded to was the working capital adjustment. There'll be a working capital balance sheet that's delivered at closing that the parties agree to. And there'll be what you call a flow of funds memo and a cash disbursement schedule. And those can be two separate documents or one document, but basically it lays out all of the people who are paid at closing with the closing proceeds or the cash payment. And so it's easy to understand the person who's selling the business is going to get paid at closing, but there's a lot of other people that may be paid at closing as well. There may be certain parties that the buyer requires to be paid off at closing. Certainly any debt holders, banks, anybody with sort of loans to the company will be paid off at closing, because most deals are closed what's called cash-free, debt-free, which means you're selling the business without cash and without any debt on the books. There are also sometimes people such as employees or contractors or other people that were promised closing bonuses or other amounts. The professionals, certainly someone like Keith who has an investment banking shop and is entitled to be paid at closing, will be paid at closing. The lawyers are oftentimes paid at closing. The accountants are oftentimes paid at closing. So there's a long list. The flow of funds memo shows that. And on top of that, you'll get third-party consents that need to be not distributed, but need to be delivered at closing. So There may be parties you have agreements with, vendors or customers that require you to obtain their consent to assign their agreement to a third party. If this is done through an asset deal, you will certainly need their permission. With a stock deal, no, you will not need their permission, and that sometimes influences which way you go with with an asset deal or a stock deal. There'll also be releases. You may have disputes with people, and the buyer may require releases. So all of that's done that day. Hopefully you don't have any open issues that are being negotiated on the closing morning. It happens quite often that you do, but the goal is always to actually exchange documents early in the morning so that wires can be exchanged before 2 o'clock, so that the money hits that day. And that's basically the sort of the closing date and how it's done and exchange of documents and funds. Thanks, Keith.
Well, thank you, Scott. So the purchase sales agreement, it's one document. There's a series of other critical agreements and contracts that have to go along, also have to be signed off on. And Andre, maybe you can kind of run through some of those other agreements and contracts that buyers and sellers need to be aware of.
Sure. Thanks, Keith. In addition to the purchase agreement, there's some other critical documents that need to be signed at closing. And just an overall comment that one document that's helpful to be prepared is a closing checklist, which sets out the responsibilities and documents of all the parties. So it's a way to keep organized and so to the closing and realize that you're missing something. So that should be done in advance. Basically, if you sold your business to a seller, the last thing you'd want him to do or she to do for you is to compete against you. So basically, you negotiate a non-compete with the buyer for some length of time and in some defined geographic area so that you're protected. And in addition to a non-compete agreement, which prevents the seller from competing with buyer for some period of time, you would also have non-solicitation agreements that they bar the seller from soliciting buyer's customers or buyer's employees. Another agreement that the parties could enter into is a management retention agreement, which Scott had alluded to, that there could be bonuses that are paid at closing or at a later date to critical employees. So it provides financial incentives for these executives or employees to remain at the company for a set period of time so that they could be provided a guaranteed incentive or a retention bonus. They're called stay bonuses, provided they remain with the company. Sometimes the seller wanted to give up operational control of the business, but they might want to stay on as a consultant. Sometimes in family businesses, there's another generation that has remained with the company when the more senior generation has departed, but they want to hang around for a period of time as a consultant, basically to make sure that everything goes smoothly for the next generation. When a company is sold in an M&A transaction and the seller is expected to provide services to support the buyer post-closing, the parties enter into a transition services agreement. These agreements can range from short back office administration functions to complex service agreements. For example, if a company sold off a division to a smaller company, part of the deal is that the larger company is going to support the smaller company with HR support, IT support, accounting support, and even sometimes legal support. And you negotiate what the period of time is and what the scope of the services and what the performance standard is for those services. Another agreement, which I think Andy or Scott had alluded to, is the Escrow agreement, which is entered into to secure post-closing indemnification obligations of the seller or any adjustments to the purchase price. A buyer negotiates for an escrow if he has concerns about the seller's ability to obligations. For example, if seller will become a shell company after closing, you want an escrow to make sure that you're going to get paid if there's an indemnification claim or a post-closing adjustment. You can put money also in escrow if there's environmental liabilities or a lawsuit or problems with accounts receivable. And the holdback goes in third-party account that may be released back to the seller if buyer doesn't make any claims. The time of the escrow is the subject of negotiation between the buyer and seller, and also what would trigger the release of the funds. The terms of the escrow are not generally heavily negotiated. The most controversial issues regarding escrows are whether you need to have an escrow in the first place, the amount of the escrow, which is usually a percentage of the purchase price. It could be 10, 20% of the purchase price, and the length of the escrow period, which could be 12 to 24 months or until the survival of the reps and warranties, and what obligations are going to be secured by the escrow and what is going to result in the release of the funds. These issues should be addressed as early as possible in the deal process so that you're comfortable that what you're paying is what you've negotiated up front. Thank you.
Thank you, Andrea. So I think we all can see even though we agreed on a price, there's a lot of moving parts when you get to the closing table. In addition to the documents we talked about. So Andy, what other kind of stuff should buyers and sellers be considering when they're ready to close the deal?
Thanks, Keith. So a lot of this depends on the deal structure. If an acquisition is a simple stock deal where the buyer is paying for the stock or membership interests of the target company and is planning to continue operating that company after closing, that saves the parties a lot of logistical steps post-closing. If, however, the buyer is making an acquisition of assets and housing them in a new company, or plans after a stock acquisition to do something like merge that entity with another affiliate, then you need to worry about some of the issues listed here, like making sure the target company's employees are properly enrolled in the acquiring company's benefit plans, that the acquiring company has bank accounts set up and other back office stuff like that. Additionally, if the deal is a sale of assets, then post-closing, the seller has an empty entity and doesn't want to use it, the seller might want to make arrangements with your attorney and accountant helping out to wind the entity down, including the payment of any outstanding taxes and other debts before making a formal filing with the state to formally dissolve the entity.
Terrific. So we've signed all the documents, all the contracts are signed. Everybody's sitting at the table. So now what? So Scott, maybe you can, how do we get it out there? Maybe you can talk a little bit about that.
So you're talking about public announcements, and there's two areas that you need to think about. There's obviously, press releases and just announcing to the public and those sorts of things. There's also the tactical communications you're going to have to make with your employees, customers, vendors to inform them about the change of control. Oftentimes, especially with employees and talking about family business or businesses that have been owned for many years by the same 2 or 3 or 4 owners, it comes as a lot of times, if they're keeping the information close to the vest, it comes as a shock to employees. And there's obviously the normal trepidation involved with employees. Oh my God, we're going to have new owners. What's it mean? So communication with the employees is actually very, very sensitive and important. It depends. Usually it's coordinated between the buyer and the seller. Usually it's done the day of the closing. And there's usually sort of an introduction between the sellers of the new buyers and new owner representatives, because if it's private equity, it might be something as simple as a new board member or someone that shows up. But you typically will have a town hall via today's world Zoom, but in the past conference calls, or if it's a one office type of business, showing up at that office and making an announcement, sort of answering questions that the employees will have. And, most importantly of all, if it's part of the plan, is to sort of comfort the employees that there's, at least in the short term, not going to be big changes in the operations of the business and the ongoing sort of ongoing business in general, because the employees are obviously most concerned about keeping their employment. Customers and vendors, it's a little bit less sensitive actually, but there may be a couple of big vendors or big customers that you want to have direct conference calls with, explain to them what's going on, same sort of communications, nothing's going to change, that sort of thing. Press release is pretty simple. The only thing that you always try to avoid in a press release is to discuss what the consideration or the amount paid for the business. But, most of the time it follows the conversations about what's going to happen with the business moving forward. There's new owners coming in. They hope to, create better support and allow the business to grow and service the marketplace better. So those are the two big constituencies there. So Keith, why don't you take it away?
All right. Well, thanks, Scott. So we all have worked with our clients for months to get deals done. And as Yogi Bear would say, it ain't over till it's over. And I thought now would be a great time to just talk to the panel about stuff that happens at the closing table, surprises. I mean, we've all run into this. And Andrew, maybe I'll start with you. Of things that you didn't think, you thought the deal was ready to go. Yeah, everybody was online, and you sit down at the table, and then boom, here it is. Maybe you can give us a little, from your experience, a war story or surprise that you had to deal with in the 12th hour.
Did you say Andrea?
Yes, please.
So, hi. I had an interesting thing happen in light of COVID, and this goes back to 2003 when I had been working on a deal for months, and we were at the closing, and we were getting ready to, we'd gone through, signed all the documents, getting ready to send out the wire transfer. And then there was the blackout of 2003 where everything shut down. And we never got confirmation immediately. It was like a few days to whether or not the deal had closed and the wire transfer had happened, because all I remember is walking down 50 flights of stairs from the law firm's office after. So that was something that's highly unusual and unexpected.
Interesting. Yeah. So hopefully it got done at the end of the day. So
at the end of the day, it did. Yes.
So how about you, Andy? Anything you want to share with us?
Sure. I mean, actually, I'd say I have a relatively small amount of stories, like literally at the closing table, because I think, what tends to happen is, as Andrea mentioned, there's a closing checklist. The parties know, what they need to do to get the closing. Stuff definitely comes up, but often it just sort of delays the closing, and the closing happens when everyone's ready. But I do have a story from earlier this year. I was representing a seller who was, just generally disorganized about everything. They're based in California, which I usually don't. Most of my clients aren't at, and no aspersions on California, but they were disorganized. And so Scott mentioned, just before the closing, there'll be a flow of funds memo where all the various payments that are going around is established. And so I got a call from the client saying, we're obviously making arrangements to pay the balance of your legal bill. We also want to make a special bonus to the attorney that works with you. We think she's been great. Do you have a problem with that? I said, not at all. That's great. It's a really great gesture. So the closing happened without a hitch. And then the day after, they gave her a call and they said, well, we kind of screwed up the calculation of the bonus pool. We don't have it. We can't make the payment. But, bottom line, I value this attorney's work, and, I'm taking care of it. So it all worked out.
Good. Yeah. How about you, Scott? Anything to share with us?
Sure. I find that typically when you get to closing and you've gone through everything, it's usually relatively smooth at closing. those aren't, there's a couple of small surprises, but what I find is as you're going through the deal and negotiating different points are where the things really pop up, whether you think you can get a consent from a third party or there's other things that show up. And the one that always jumps out at me, we were negotiating a deal to buy a division of a multinational company out of the UK. And the business development folks that were located in the US were not thinking about UK law and how to transfer employees and things like that. And their legal system in the UK, at least with employees, is very different than the US. They don't have employment at will. There's all kinds of severance obligations. And so we were actually negotiating different deals because of the costs involved in transferring those employees. So thankfully, we were aware of it and we sort of had a plan in mind how to address it. But that could have just easily cratered the entire deal after, weeks and weeks of negotiating. So those are the kinds of things that pop up. I think, when you have good professionals around you, they're thinking down the road and what issues are there and what things haven't come up that you need to deal with, through the process. Because if the buyer or the seller is working in this situation and doing their diligence, these issues always arise. So you should always have a plan as you're going through the transaction to address things that ultimately will come up.
Terrific. So this has been a great overview of the closing process. I hope everybody got some great information from the panel. At this point, I'd love to open it up to questions, and I'm going to turn it over to Larry. Larry, if you, any questions you receive, you want to direct it right to the individual panel, that'd be terrific.
Oh, that's great. And I just want to say that we really have had three, brilliant attorneys with us today with a wealth of experience. If each of them has 500 eyes, we had 1,500 eyes on this process today. So I want to ask this first question to Andrea that arose. What's the biggest factor, in your opinion, that can result in a bad acquisition?
Thanks, Larry. I think I can't emphasize the importance of extensive due diligence, because if someone does sloppy due diligence, there could be a lot of things that could happen that come to bite you in the end. Like Andy and Scott said, when you get to the closing, there's very little surprises, assuming everything has gone smoothly. A lot of times in the course of the process, deal momentum carries you forward. And I worked for a CEO who said, you got to get the deal done. We got to get this deal done. Like, it didn't matter. There was an issue with indemnification and a very low cap. And he's like, we got to get the deal done. And it turned out in the end that the company fell apart and that indemnification cap was way too low for the issues that arose. And a lot of times, like when you're putting two companies together, you're putting two cultures together, and there's an integration between the two companies. But I can't emphasize the importance, like Scott said, about the communication with the employees after the deal closes. So, be sensitive to what the culture, and make sure that there's a good cultural fit between the companies, because if you don't have the cooperation of the current employees and their momentum behind you, then it might not be a successful acquisition.
All right. Well, thank you. That's great insight. And I'm going to just make a note. I think all of you, certainly, Andy and Scott, have talked about the employees. All of you have. And my area of expertise is employee benefit plans. And I know that it might not happen at the closing, but all documents, just as a note, to transfer the plan administrators, the trustees, for instance, of a retirement plan, all the SBC, the summary documents needed on an ERISA regulated group medical plan, and all the similar plans should be all laid out in advance, ready to execute after closing. I'm just going to mention that. Now, I wanted to ask this one to Andy, but anyone can answer after that. Well, you know, all these documents pertain to deals probably of any size, but can you clarify, is there a difference in closing between small deals and larger ones? Andy?
Yeah, I mean, I would say that there's less of a difference than you'd imagine. You know, certainly, you know, a higher purchase price is usually going to indicate more complex and extensive operations, and that drives the size of the disclosure schedules. And you know, if it's an asset acquisition, the complexity of transferring all the assets. But the basic agreement used, you know, for a $1 million deal and $1 billion is pretty similar. I mean, you know, larger deals, if it's very large, it could have a like regulatory approval, like a Hart-Scott-Rodino filing. But again, it's largely pretty much the same, and that actually creates a challenge with smaller acquisitions because there's a lot of work to be done by the attorneys and the other advisors, and work takes time, and time is money. And if the seller is getting a relatively smaller amount in purchase price, then it becomes, you know, you have to be really careful about hiring your advisors in a cost-effective manner. So that can be a challenge.
Thank you for that. And I'm just wondering if those more complex deals, perhaps, are there mock closings with all the parties present? Ever conduct a mock closing? Anyone could take that one.
Did you say whether you detect in-person closing? Did you say?
No, I'm saying a mock, like a trial closing. Everyone in the room, but it's not the real closing. It's a trial, like a practice closing.
There used to be pre-closings where you had pre-closings where you had everything laid out. It used to be in the old days, everything gone over and laid out before you had the actual closing. So that was sort of a dress rehearsal, because then things came up and you discovered things that were needed. And then the closing could get delayed if there was something that, like a consent wasn't obtained that was needed, or the company turned out it wasn't in good standing and something had to happen.
Oh, that's exactly what I mean. As a matter of fact, I'll ask you, Andrew, what do you do if consents from third parties like customers or employees, you know, can't be, you know, they're required under the agreement, but haven't been achieved by closing day? How would you handle that?
I mean, I can handle that. I mean, you know, the agreement will be structured such that it's a condition to closing that the necessary conditions, necessary consents be obtained. And it's really, if it just can't be on time, then it's up to the buyer, you know, whether to delay the closing further to give the seller more time to get the consent, or to, as they say, close over the failure to get the consent. It depends on how important the particular consent is, whether it's a key contract for the you know, for the business.
That's very helpful. You know, I'm going to sort of wind up with one all-encompassing question. If you guys can mute a little bit, so people here. One encompassing question is the deal really done at the closing? Like, the deal might be papered, but is the deal done? Or is there a lot that remains after that?
I can answer that. So there's going to always be post-closing obligations. So it's pretty simple that no, it's not done at the closing. Oftentimes your reps warranties will survive for, you know, 12 to 18, even sometimes 24 months. So your indemnification obligations are going to last as long as those reps and warranties survive. But on top of that, you know, there may be other things that you have post-closing covenants or post-closing obligations that you have to comply with. So there may be, you know, transferring of other things. Sometimes you're getting regulatory approvals still, and those are open, and you have to continue to prosecute those to get them completed. So it's a pretty simple no, the deal is not closed at closing or done at closing.
And I would presume that things like, in my instance, it was licensure. So if a license lapsed, I would have a right to cure. So are those protections usually built in?
They are, if you're, that's one of the things if you're thinking about those things, right? So oftentimes there's agreements I see that even if you can't get a proper consent, there's language about, the seller continuing to quote service those clients. They're not really doing it because the buyer now has all assets, but there's provisions about that. There's provisions about all kinds of things. And there's always the catch-all in every M&A document that, the buyer and the seller will take all steps to, sort of see through the intent and the parties' relationship. So you always have those obligations.
That is great. Thank you for answering all these questions. And I turn it back to you, Keith.
Into preparing for this webinar today. The contact information is now up on the screen. If anyone wants to contact any of us, please feel free. Also would like to thank the whole USA 500 Match group. We began this process of putting this together back, I believe, in May with a launch date of October. We were able to put together 7, I thought, very informative sessions about the selling process. Hope all the attendees benefited from it, took away something from it. That was our goal. I appreciate everybody's time. Wish you all a happy holiday, and please stay safe and well. And thanks again for attending. Have a great day.
Thank you, Keith.
Thank you.
Thank you.
Thanks, Keith.
Thanks, everybody.